recognizing that despite our best efforts, we cannot prevent all incidents of gun violence.
But it also includes countless shootings that take place every day, devastate families.
By actually taking guns away from dangerous, violent felons.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
We are the only nation in the industrialized world that tolerates such gruesome statistics.
It bans for everyone ammo magazines that are in pervasive use.
When someone does something to your family members that is illegal, we need to take them off the streets.
Major argument in Reese versus Batfee case. All right, gather around, folks. We're diving into the ring of a legal showdown that's got the whole firearms world buzzing. Picture this. We're in the heart of New Orleans, Louisiana, and the stage is the United States Court of Appeals for the Fifth Circuit. It's where the big league legal battles go down, and today's star of the show is none other than the case of Reese versus the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
40 million firearms with stabilizing braces currently in circulation.
Recognizing that despite our best efforts, we cannot prevent all incidents of gun violence.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Now, let me introduce you to the main event players. On one side, we've got a group of young adults aged 18 to 21 who are itching to get their hands on firearms. And on the other, we've got the heavyweight champ Batfee looking to block them. It's like a classic David and Goliath scenario with the twist that both sides are American citizens. But what's the beef here? Well, it all boils down to a simple but crucial question. Can these young adults legally buy guns from the pros, the federal firearms licensees? It's like the ultimate ID check at a bar. Are they old enough to bear arms? The Second Amendment is the big player in this game. It's like the rule book of the U.S. when it comes to guns, and one key phrase in it is the right of the people. Now, here's where things get tricky. Does the people include everyone from age 18 to 21, or is it a VIP club reserved for folks 21 and up? That's the million-dollar question. What makes this whole thing even juicier is a blast from the past. You see, back in the day,
with the kind of weapon that we will be voting to ban today.
And on the table, you could pretty much say that falls in the category of a weapon.
But it also includes countless shootings that take place every day, devastate families.
The Militia Act of 1792 was like the law of the land. It said that 18 to 20-year-olds had to get their own guns for militia duty. So how can you argue that they weren't considered part of the people back in 1791 when the Second Amendment was ratified? The legal magic word here is historically. The government needs to prove that, historically, 18 to 20-year-olds weren't allowed to have guns. But that's like trying to prove that unicorns never existed. It's a tough nut to crack. And here's where it gets real interesting. The case's outcome might not just affect these young adults. It could redefine who the people really are in the Second Amendment. It's like adjusting the settings on a video game. If they win, it's a new level unlocked for young gun enthusiasts. Now, stay tuned for the next round, because if the Fifth Circuit decides against the government, it's almost certain to head to the U.S. Supreme Court. That's when things will get really spicy, and this case could become the headline grabber of the Second Amendment world
by actually taking guns away from dangerous, violent felons.
The Constitution has a right to keep and bear arms
in 2024-2025. So, there you have it, folks. A legal slugfest in the heart of the Big Easy, pitting young gun enthusiasts against the mighty Batfee, all hinging on whether the people includes 18 to 21-year-olds. This one's far from over, and it's a battle that could change the rules for firearm ownership in the good old US of A. Stay tuned for the next exciting episode of Reese vs. Batfee. The right to acquire firearms. So you might be wondering, why does this matter so much? Well, it's not just about words on paper, it's about the real impact on the lives of these young folks. Can they legally buy and carry firearms just like their older counterparts? Or are they left feeling like they're at a banquet, but the food's just out of reach? Now, remember that historical context I mentioned earlier? It's like a powerful piece of evidence in this case.
Does behavior change the interpretation of the Second Amendment?
By conducting background checks refusing to sell to those who are not allowed to have firearms, and keeping records.
The Militia Act of 1792 is like a time machine that takes us back to the days when the Second Amendment was fresh off the press. And guess what it says? It mandates that those aged 18 to 20 should get their own firearms for militia duty. In essence, they had the green light to buy their own guns. So when you're debating whether these young adults were part of the people back in 1791, you're practically swimming upstream. How can you say they were excluded from the Second Amendment's The Right of the People Club when the law at the time practically handed them a membership card? But let's zoom in on those key terms, keep and bear.
Today we take another step to advance historic gun violence prevention legislation. We are the only nation in the industrialized world that tolerates such gruesome statistics.
You see, this debate isn't just about semantics. It's about what it means to possess and carry firearms. Can young adults aged 18 to 21 legally have guns in their closets just like the rest of us? And can they take those firearms out for a spin, showing them off in public without breaking the law? Now here's the fun part. If this case goes in favor of these young adults, it's not just a legal victory, it's a win for their rights. It's like saying, yes, you're part of the people in the Second Amendment, and you can enjoy all the rights that come with it. It's like unlocking a new level in a video game, where they get to exercise their Second Amendment rights to the fullest.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
That the right to keep and bear arms is an individual right possessed by Americans.
But don't pack up your bags just yet. The story is far from over. If the Fifth Circuit rules against the government, this case is almost guaranteed to make its way to the U.S. Supreme Court. That's when things are going to get even more exciting and dramatic. It's like the grand finale of a thrilling movie, with the fate of these young gun enthusiasts hanging in the balance. Legal background and historical references. First up, we've got some federal law in the ring, specifically 18 U.S.C. 922b1b1 and 922c1c. These are like the heavyweight regulations that say, hey, FFLs, you can't sell firearms to folks under 21. It's like a stern doorman at a club who checks IDs and says, sorry, you're not on the list. Now, the interesting part is that these regulations are at the heart of the dispute. The big question is whether they pass the Second Amendment test. Do these rules, which effectively bar young adults aged 18 to 20 from buying guns from FFLs, hold up when we consider the broader context of the Constitution?
When someone does something to your family members that is illegal, we need to take them off the streets.
It's repeated over and over again that the Second Amendment is unlimited. Is not unlimited. It has limits.
They seek to eliminate the law enforcement agency responsible for protecting communities from gun violence.
And historical references? And that brings us to the legal burden. See, in a legal face-off like this, the burden of proof isn't on the young adults fighting for their rights. It's on the government to prove that historically, 18 to 20-year-olds were not allowed to acquire firearms. It's like they're the ones who have to convince everyone that unicorns don't exist, and that's no small feat. So when you've got a history that seems to suggest otherwise, like the Militia Act of 1792 that required young adults to get their own firearms, the government is facing an uphill battle. It's like trying to convince a jury that the earth is flat when everyone knows it's round.
And I don't think there's any doubt that this administration is more pro-gun control than the past administration.
Let me be clear. We all respect the Second Amendment, but it's not without limits. Imagine how much we could get accomplished.
In a way, this legal background and historical context are the battlefield where this fight is happening. The young adults are saying, look at history, look at the law, we've got a strong case, while the government is trying to prove, no, there's more to it, and this regulation is necessary. This whole showdown is like a chess match. Each side is trying to strategically position their pieces to claim victory. If the government can't demonstrate convincingly that these young adults historically didn't have the right to bear arms, it could be a game changer. Potential impact on the Second Amendment. The Second Amendment speaks of the right of the people to keep and bear arms, and if the court says that this includes those aged 18 to 21, it's like opening the door for them to fully exercise their Second Amendment rights. This would define who the people are under the Second Amendment in a broader and more inclusive way. So it's like adjusting the settings on a video game. Young adults get to level up.
Under the new rule, these firearm owners will be required to obtain special registration. Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
It is improper. You cannot ban weapons that are, quote, in common use at the time.
And enjoy the full array of rights that come with being part of the people. They'd have the green light to buy and carry firearms, just like the rest of us. It's a victory that could have a far-reaching impact, not just for the young folks involved in the case, but for anyone who cherishes their Second Amendment rights. But wait, there's more. This case isn't just about firearms, it's also shining a spotlight on ancillary rights. Think of it as the supporting cast in a blockbuster movie. The Second Amendment is all about guns, but there are other rights hanging in the balance here. We're talking about the right to acquire firearms, ammunition, and related aspects. The case might spark discussions about what these rights mean in the modern context. Can we really exercise our Second Amendment rights if we can't acquire the tools that make it possible, like ammunition and accessories? So the Reese versus Batfee case is like the opening act of a grand performance.
To ban guns and violate the Second Amendment rights of American citizens.
Transfer or possession of semi-automatic weapons and large-capacity ammunition feeding devices.
If it goes the way many hope, it'll lead to discussions about the broader spectrum of rights that surround the Second Amendment. It's not just about what you can do with a gun, it's also about what you need to make it work, like the bullets in your magazine and the holster on your belt. In a way, this case could set the stage for a more comprehensive and nuanced understanding of what the Second Amendment entails. It's like the sequel that goes deeper into the characters and their motivations. We might get a better grasp of what it means to be part of the people and what rights that entails in the 21st century. That's all for this video, folks. See you next time.